and welcome back to Chapter 15 in Healthcare Law and Ethics. We are picking up in Section 4 that starts on page 358. We're going to skip a good bit of this and we're going to skip over to 359 on deceased patients. Now, HIPAA states that an individual has the same privacy rights in death as they did in life, but it leaves it up to the states in terms of who qualifies as the deceased person's legal or personal representative for access, use, and disclosure. High-tech modifications to HIPAA provides for flexibility in the disclosure of a decedent's PHI by 1. Removing the PHI from status removing the PHI status from health records 50 years following the patient's death, and 2. Permitting covered entities to disclose decedent records to family members and others involved in the patient's care or payment of care unless doing so would be inconsistent with any known preference of the patient. So basically what that's saying is if I die tomorrow, that for 50 years the privacy protections would still be in place for my information just as if I were alive. But after 50 years goes by, then they're going to remove the PHI. It's no longer protected health information. So 50 years, remember that number, 50 years for information on deceased patients. After 50 years, it becomes no longer PHI. Okay, now it says, although PHI status has been removed 50 years following a patient's death, it does not mean a healthcare provider must keep the information for 50 years. So the privacy rule does not address record retention, so your state retention laws are still going to be in place and followed. All right, now flipping over to 360, let's get into disclosure, which I don't really have slides for disclosure of information to a medical examiner. But again, upon death, an autopsy may be required to determine the patient's cause of death. So the privacy rule allows the release of PHI without authorization to a medical examiner or a coroner for identifying the deceased person. So we don't have to have a personal representative or anybody like that to release information to a coroner or a medical examiner. That's automatic. Okay, we're going to skip open records. We're going to skip employee. We're going to skip anti-terrorism, skipping consumer registry, and we're going over to 364, and we're going to look at payment requests for insurance companies. Now, insurance companies commonly request patient information. Now, in accordance to HIPAA privacy rule, requests for payment purposes, including utilization review and medical necessity review, do not require authorization if the information is for payment for the specific episode of care. So remember, TPO, treatment, payment, healthcare operations. So if we are releasing information to an insurance company for payment purposes, then we do not have to have that authorization. However, other insurance company information requests may require patient authorization. An insurance company acting on behalf of the healthcare organization does not require an authorization, okay? Now, be sure to read through that section just to be familiar with it. But again, if you're releasing information to an insurance company for payment purposes, it does not have to have an authorization. All right, let's look at medical emergencies. So we talked about some medical emergencies in the past that we've talked about how people can't get in trouble for treating them. You can't get in trouble for, battery because you treated them without the consent. Well, in medical emergency situations, the obligation is to treat the patient and provide whatever information is necessary. This usually entails disclosing patient information without authorization. So again, if they can't consent to the procedure, they can't authorize you to release the information as well. But if such a disclosure occurs, it's prudent to document the content and the nature of the disclosure, whether you talk to somebody over the telephone, whether it's, however that happened, whether you fax something to another facility, it just needs to have documentation to cover it. Okay. All right, now let's get into public figures and celebrities. Now, News media personnel and others may have an interest in obtaining information about a public figure or celebrity who is being treated or about individuals involved in events that have cast them in public eye. So, again, we're talking about Elvis Presley going and being admitted to North Mississippi Medical Center, or we're talking about a tornado hitting the Tupelo Bancorp South Arena while there's a concert going on. Basically, what this is saying is like we're getting into the media and we're getting into employees, computer access. Employees don't need to be going looking seeing what's wrong with Elvis. They don't need to look up and see, oh my God, my sister was at that concert. Let me check and see if she's coming to the ER and things like that. Now it says media is not exempt from the restrictions imposed by the privacy rule. Okay. So a healthcare organization may wish to exercise even greater restraint than that mandated by the directory requirement with respect to the media in order to ensure patient confidentiality for your public figures and celebrities. So an example, it could be recommended that no information be provided about the location of a patient who is the subject of a media inquiry. Special care should be taken to ensure that patients who are the subjects of media inquiry give authorization for any information to be disclosed or for photographs and interviews. So, as a healthcare organization may consider implementing policies and procedures for assigning an alias to patients who are public figures or celebrities and placing their health records in a separate, secure area. The information is secured electronically. A process that restricts access on a need-to-know basis should be considered. Because again, nobody needs to get into that information. All right, I think that's going to really cover all I'm going to cover for us. So, we're going to skip the check your understanding on 15.4. And I will catch you in section 5. We're going to cover the majority of section 5. It's a big section. It's got a lot of information, and it gets really more into the nitty-gritty of the actual HIM department and the functions that they are providing. So we will cover the full section of section 5. So happy reading and happy studying.